So I hope that it may be helpful to look at some examples where these three menu items have been put into the mixer of a WSIAT hearing, and we can see how the result turns. The first example I'll give you is a case where the plaintiff is a truck driver, and he used to own his own truck, but then he subsequently makes a new arrangement. He sells his truck to A-Team Haulage Company, and he incorporates his own number company, and through that number company he supplies himself as a driver to A-Team. He basically is driving that truck that he used to own, and he bills $19 an hour because that's what A-Team tells him he can bill. There are no other employees of his numbered company. The truck has an A-Team logo, and the plaintiff has to accept loads from A-Team. He can't refuse them, and it turns out that the plaintiff did not advertise his business to anywhere and didn't work anywhere else. Of course, it turns out that the truck he used to own and now is owned by A-Team has a defect in it. And while operating the truck on a job for A-Team, the plaintiff is injured, and he sues the owner of the truck, which is A-Team, and he claims statutory accident benefits. The insurer of A-Team makes an application under Section 31 of the Workplace Safety and Insurance Act for a declaration that the plaintiff's right of action has been removed by the provisions of the Act, the provisions being Section 28. In this particular case, the tribunal found that because the hourly wage was fixed, that there was no opportunity to make a profit by doing the work differently, and there was no opportunity, no risk of suffering a loss for doing the job badly. The tribunal said that the existence of incorporating that numbered company through which to operate and bill was a factor indicating that he was an independent contractor, but it was outweighed by other important factors, such as A-Team's control of the work, A-Team's ownership of the truck, and basically the integration of the plaintiff into A-Team's operations. And the tribunal held that that right of action was taken away. There have been cases more recently dealing with incorporated consultants who are placed by personnel firms. Here in Ottawa, we call them body shops. We send professionals out to work in government offices and in the private sector, and they have a contract with them, but usually the body shop has got a piece of that contract. In that decision, the tribunal has said that the fact that there is an incorporated professional, it can't be ignored and has to be given some significant weight in weighing that whole factor. And in the end, they upheld the independent contractor status of those consulting professionals. I'd suggest to you, though, that in reading that decision, I think the tribunal looked very hard at the fact that the professionals were really controlling how the work was done, and the way that they applied their skill and judgment had an impact on how many jobs they were going to get, and therefore there was a risk of loss and a chance to make a profit.